Hello everyone. In the preceding presentations, we have seen the various kinds of law which provide rights and liabilities to the individuals and which define offences and provide punishment for the offences, that is, substantive civil law and substantive criminal law. And we have also seen the various kinds of procedural law that provide for the procedure that has to be followed in the case of civil and criminal proceedings, and the procedure for adducing evidence in civil and criminal cases. Now, which court has to be approached for redressal of grievances or for enforcing civil rights or prosecuting persons accused of commission of offences? For this, we have to understand the system of courts that exist in India. As we all know, the most essential function of the state is administration of justice. The state, through judiciary, exercises power to enforce rights and punish wrongs. Any legal proceedings, whether civil or criminal, involves two parties, the plaintiff and the defendant in civil cases, and complainant or state, who is the prosecutor and the accused in criminal cases. Judicial process involves four stages. 1. A right claimed or a wrong complaint by one party against the other. 2. Hearing of the parties by the court. 3. Judgment of the court delivered at the end of the trial. And 4. Execution of the operative part of the judgment. All this is done by the courts. And so far as the system of courts in India are concerned, at the national level we have the Supreme Court, at the state level we have the high courts, and these are constitutional courts, that is, the organization, powers and functions of these courts are provided in the Constitution of India. At the district and subordinate level, there are subordinate civil and criminal courts in the state which are under the supervision of the High Court of the state. The Supreme Court of India is the court of record, that is, whose records are admitted to be of evidentiary value and are not questioned when they are produced before the court. It has the power to punish for contempt of court. The Supreme Court has original jurisdiction to deal with disputes that arise between the center and one or more states or between states. It is the highest court of appeal for certain civil and criminal cases, especially where question of law is concerned. It also has the jurisdiction to issue writs for enforcement of fundamental rights of individuals against the state, that is, organs of governance. The Supreme Court also exercises the power to give advisory opinion to the President when a question of law or question of public importance is referred by him. Law declared by the Supreme Court is binding on all the courts in India. So far as the jurisdiction of high courts are concerned, they also are the courts of record and have power to punish for contempt. Original jurisdiction in civil and criminal matters is available to high courts of Bombay, Madras and Calcutta. The high courts also have appellate and revisional jurisdiction in civil and criminal matters decided by subordinate courts. Writ jurisdiction is available to the high courts under Article 226, and they exercise these powers to enforce fundamental rights as well as any other legal right. Under Article 32, however, the power to issue writs is available to the Supreme Court to enforce fundamental rights only. So far as the organization of courts at district level is concerned, civil courts subordinate to the High Court administer civil justice, and criminal courts subordinate to the High Court administer criminal justice. Civil justice is about enforcement of rights and is remedial, whereas criminal justice is about punishing the wrongdoer and hence is punitive. Proceedings in civil courts are regulated by Civil Procedure Code, and proceedings in criminal courts are regulated by the Criminal Procedure Code. The subordinate judiciary on the civil side in cities include the Chief Judge and Additional Chief Judge constituting the first grade courts, Assistant Chief Judge or Senior Civil Judge constituting the second level, and the Munsif or Junior Civil Judge constituting the third level of civil courts. In the districts, it is the District Judge and Additional District Judge at the first level, Assistant District Judge or the Senior Civil Judge at the second level, and munsif or junior civil judge at the third level of civil courts. While the district judge heads the civil justice administration in districts, the chief judge heads the civil justice administration in cities. Additional chief judges and additional district judges assist the chief judge and the district judge in administration of civil justice. Judges of first and second grades possess both original and appellate jurisdiction. Judges of first grade may also be conferred revisional powers. Small causes courts set up under the Provincial Small Causes Courts Act are empowered to try matters of small nature not involving questions of title. The procedure followed is simple and quick. So far as criminal courts subordinate to the High Court are concerned, there are courts of session manned by Sessions Judge, Additional Sessions Judge, and Assistant Session Judges. Under them, there are Chief Judicial Magistrates in districts, Chief Metropolitan Magistrates in cities, and Subdivisional Magistrates in subdivisions, and also Special Magistrates. Under Chief Judicial Magistrates, there are Judicial Magistrates of first and second class, and under the Chief Metropolitan Magistrates, there are Metropolitan Magistrates. Under the Subdivisional Magistrates, there are again Judicial Magistrates of first class and second class. Thus, for the purpose of criminal justice administration, each state is divided into sessions divisions, which are usually districts. There is a court of session in each sessions division. As we have already seen, Sessions Judge presides the court of session, and he is assisted by additional and assistant sessions judges. So far as criminal justice administration is concerned, Chief Metropolitan Magistrate is in charge of a city, Chief Judicial Magistrate is in charge of a district, and a Subdivisional Judicial Magistrate is in charge of subdivision. All judicial magistrates of first and second class, including Chief Judicial Magistrate, Chief Metropolitan Magistrates, and Subdivisional Judicial Magistrates, are subordinate to Sessions Judges. So far as sentencing power of criminal courts are concerned, the Sessions Judge and Additional Sessions Judge are empowered to pass any sentence authorized by law, including death sentence, but when death sentence is passed, it has to be confirmed by the High Court. Assistant Sessions Judge can pass a sentence of imprisonment for not more than 10 years and fine authorized by law. Chief Judicial Magistrate and Chief Metropolitan Magistrate can pass a sentence of imprisonment up to 7 years and fine authorized by law. Judicial Magistrate of first class and Metropolitan Magistrate can pass a sentence of imprisonment up to 3 years and fine not exceeding Rs 10,000. Judicial Magistrate of second class can pass a sentence of imprisonment up to 1 year and fine not exceeding Rs 5,000. We all know that the three organs of government are the legislature for making laws, executive for enforcing laws, and judiciary for interpreting laws and resolving disputes. According to the doctrine of separation of powers, same person should not be a part of more than one of the organs of the government. One organ of the government should not interfere with any other organ of the government, and one organ of the government should not exercise the function of any other organ of the government. This is to ensure that one organ does not exercise undue influence over the functioning of the other organ of the government. The Constitution of India provides for separation of executive from the judiciary under Article 50 in order to ensure independence and impartiality of judiciary. In pursuance of this, two categories of magistrates have been created, the executive magistrates and the judicial magistrates. Executive magistrates are appointed and controlled by the state government and are responsible for the maintenance of law and order. Judicial magistrates are appointed and controlled by the High Court and perform judicial functions. Executive magistrates for districts include the district magistrates, additional district magistrates, and executive magistrates. The executive magistrates for subdivision include the subdivisional magistrates, additional subdivisional magistrates, and executive magistrates. Special executive magistrates are appointed by the state government for particular areas or for the performance of particular functions. This is all about the hierarchy of courts in India. The courts in which a suit for a civil dispute has to be filed depends on factors like the value of the suit, place where the parties to a suit reside, the place where the violation of a right took place, etc. The court in which a criminal prosecution has to be filed depends on factors like the place where the offence is committed and the maximum sentence that can be awarded for the offence alleged to have been committed by the accused, etc. Detailed provisions pertaining to these aspects are contained in the Civil and Criminal Procedure Code. Thank you.